Good day. I am Dr. Martha Bradley, lecturer at the Department of Public Law, Faculty of Law at the University of Pretoria. Welcome to your lecture on the withdrawal from treaties. The purpose of this lecture is to provide how a state withdraws from a treaty. The relevant law concerned with the withdrawal from a treaty is codified in Articles 54 and 56 of the Vienna Convention on the Law of Treaties, also referred to as the VCLT. These two provisions, already at the time of codification, equated customary international law status and thus bind all states, irrespective of whether or not the state is party to the VCLT. In accordance with Articles 54 and 56 of the VCLT, the first question that needs to be asked in order to determine when a state can withdraw from a treaty is whether the specific text of the relevant treaty provides for withdrawal or regulates withdrawal. If the answer is yes, then in accordance with Article 54 of the VCLT, the relevant treaty itself will describe the withdrawal procedure. If the answer is no, if the treaty is silent on the issue of withdrawal, then we turn to Article 56 of the VCLT for guidance. I must emphasize that there is a general presumption against withdrawal. I will now unpack the Article 54 and Article 56 situations separately. Article 54 of the VCLT determines the following. Article 54, VCLT. Termination of or withdrawal from a treaty under its provisions or by consent of the parties. The termination of a treaty or the withdrawal of a party may take place A. In conformity with the provisions of the treaty. I repeat, this is important. In conformity with the provisions of the treaty, or B, at any time by consent of all the parties after consultation with the other contracting states. As per Article 54A of the VCLT, and it's important that you know the difference of the content and memorize Article 54A and Article 56 because you will have to employ this in practice. So as per Article 54A of the VCLT, the termination of a treaty may take place as stipulated in the text of the treaty itself. Therefore, the point of departure is to look at the text of the treaty itself. Ask yourself whether the treaty from which your state wishes to withdraw has a withdrawal clause. I repeat, check the specific treaty which your state wishes to withdraw from to determine if it has a withdrawal clause. That is what Article 54A of the VCLT tells us to do. I offer the Rome Statute of the International Criminal Court as example. You will recall that South Africa wanted to withdraw from the Rome Statute during the Zuma administration. On 19 October 2016, the South African Cabinet took the decision that South Africa would withdraw from the Rome Statute by immediately submitting the instrument of withdrawal to the Secretary-General of the United Nations. Later, on 10 March 2017, South Africa revoked its notice to withdraw from the Rome Statute of the International Criminal Court. In accordance with Article 54 of the VCLT, the state law advisors at the time had to turn to the Rome Statute itself to establish whether this instrument expressly provided for withdrawal. Indeed, Article 127 of the Rome Statute does provide for withdrawal. I turn to the text of Article 127 of the Rome Statute. Article 127(1). A state party may, by written notification, addressed to the Secretary-General of the United Nations, withdraw from the statute. The withdrawal shall take effect 1 year after the date of receipt of the notification, unless the notification specifies a later date. A state shall not be discharged by reason of its withdrawal from the obligations arising from the statute while it was a party to the statute, including any financial obligations which may have accrued. Its withdrawal shall not affect any cooperation with the court in connection with criminal investigations and proceedings in relation to which the withdrawing state had a duty to cooperate and which were commenced prior, this is important, prior to the date on which the withdrawal became effective, nor shall it prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which this withdrawal became effective. So it's very important that you carefully consult Article 127, 1 and 2 of the Rome Statute if you wanted to advise your state on the possibility of withdrawal. So, Article 127 specifies not only the procedure of withdrawal, but also the consequences and timeframes of the process of withdrawal. You will note that as per Article 127.1, a state has to submit a written notification of its intention to withdraw, addressed to the Secretary General of the United Nations. South Africa did comply with this requirement as it submitted the instrument of withdrawal to the Secretary General of the United Nations on 19 October 2016. According to Article 127.1 of the Rome Statute, South Africa will remain a party to this treaty for a period of 1 year as from the date of submitting the intention to withdraw. In this specific case of South Africa, however, South Africa withdrew the intention to withdraw, and South Africa remains a party to the Rome Statute. Withdrawing from an intention to withdraw is rather unheard of in international law, and the law of treaties is not specific. This is indeed uncharted territory. The parties to the Rome Statute, however, did not contest or challenge South Africa's withdrawal from its intention to withdraw, and South Africa remains a member state. The government of Burundi, on the other hand, did withdraw successfully from the ICC. It became the first country to do so and accused the ICC of deliberately targeting Africans for prosecution. The government of Burundi, however, did withdraw from the ICC. It became the first country to do so and accused the ICC of deliberately targeting Africans for prosecution. On 27 October 2016, Burundi gave notice of its intention to withdraw from the ICC in accordance with Article 127 of the Rome Statute. Its withdrawal took effect on 27 October 2017, as Article 127 stipulates that a state's withdrawal takes effect 1 year after the date of receipt of the notification of withdrawal. Article 127.2 explains the consequences of withdrawal. The prosecutor of the ICC may still investigate and pursue the commission of crimes under the jurisdiction of the ICC for the period or the duration of the period of Burundi's membership as a state party of the Rome Statute. For example, the ICC prosecutor at the time, Madame Fatou Bensouda, opened a preliminary examination into the situation in Burundi in April 2016, focusing on cases of murder, torture, rape, and enforced disappearance committed since April 2015. This was in the period that Burundi was still a member state, which may constitute war crimes under the ICC's jurisdiction. Since the proceedings, a preliminary examination in this case were initiated prior to the date of Burundi's effective withdrawal, the prosecutor could request the opening of an investigation into international crimes committed by Burundi before 27 October 2017. So Article 1272 explains the effect of withdrawal. I offer another example of a state withdrawing from a multilateral treaty. This is the example of Japan's withdrawal from the International Convention on the Regulation of Whaling. On 26 December 2018, the Japanese government announced that it had decided to withdraw from the International Convention on the Regulation of Whaling. The Japanese government simultaneously declared that Japan would resume commercial whaling in its territorial waters and exclusive economic zone and cease its research whaling in the Antarctic Ocean in July 2019, when the withdrawal came into effect. On 14 January 2019, the International Whaling Commission received a notification that the government of Japan would withdraw from the International Convention for the Regulation of Whaling in 2019. This notification was received by the United States as depository for the convention and thereafter communicated to all IWC member governments. Japan's withdrawal was in accordance with Article 54 of the VCLT, as Article XI of the International Convention on the Regulation of Whaling makes provision for the withdrawal of states. You will now see this provision on your screen. Any contracting government may withdraw from the convention on 30 June of any year by giving notice on or before the 1st of January of the same year to the depository government, which upon receipt of such a notice shall at once communicate it to the other contracting governments. Any other contracting government may, in like manner, within 1 month after receipt of a copy of such notice from the depository government, give notice of withdrawal, so that the convention shall cease to be in force on 30th June of the same year with respect to government giving such notice of withdrawal. In accordance with this provision, Japan resumed commercial whaling as of 1 July 2019. I now turn to Article 56 of the VCLT, which regulates situations where the treaty from which a state wishes to withdraw is silent on this issue, or, in other words, contains no withdrawal clause. I will now examine the text of Article 56. Article 56 of the VCLT concerns the denunciation of or withdrawal from a treaty containing no provision regarding termination, denunciation, or withdrawal. So those are the cases to which Article 54 does not apply. Article 56(1) of the VCLT. A treaty which contains no provision regarding its termination and which does not provide for denunciation or withdrawal is not subject to denunciation or withdrawal unless A. It is established that the parties intended to admit the possibility of denunciation or withdrawal, or B. A right of denunciation or withdrawal may be implied by the nature of the treaty. So you can see that there's a presumption against withdrawal. 56(2). A party shall give not less than 12 months' notice of its intention to denounce or withdraw from a treaty under paragraph 1. In the event that a treaty does not provide for withdrawal, there exists a presumption against withdrawal. In such a case, a state may only withdraw from such treaty if it can be established that the parties to the said treaty indeed intended withdrawal to be possible, or if a right of withdrawal was implied by the nature of the relevant treaty. If either of these two requirements listed in Article 56 of the VCLT is satisfied, then a state may withdraw after 12 months of receipt of its notice of intention to withdraw. In summary, how does a state withdraw from a treaty? First, you need to determine whether the specific text of the treaty provides for withdrawal. This is in accordance with Article 54 of the VCLT. If the answer is yes, The withdrawal clause will stipulate the procedure of withdrawal, the relevant time period after which the state no longer is a party, and the consequences of withdrawal. If the answer is no, and the specific treaty text does not provide for withdrawal, in other words, if the treaty from which a state wishes to withdraw does not contain a withdrawal clause, then Article 56 of the VCLT applies to withdrawal for such treaty. This brings us to the end of your lecture on withdrawal from treaties. Thank you for your attention.